You look great, though, even if it's on your phone.
Thank you.
So it's perfect.
Hi.
And I'm so glad that you're here joining us today. Thank you. You have such a wealth of knowledge and are such a wonderful music attorney out there in the world, and taking time to share your insight with all of us is amazing. We can't thank you enough.
My pleasure. Yeah.
So we have questions that came in prior to this session, and then some that might come up. We'll open it up for some Q&A at the end. So if you guys do have questions, put them in the chat. If they kind of come up, we'll go through a couple of questions that came in previously, and we'll just see if we can get to the bottom of some of your questions that you guys have been asking throughout the class when it comes to sync and songwriting. And then first, I just wanted to talk with Erin and have you tell us a little bit about yourself and what you do and the scope of your world, and where you come from.
Yeah, for sure. So as you said, I'm a music attorney, and I am a transactional music attorney, which means I handle all the contracts. I don't do the lawsuits. That would be a litigator. So infringement suits and breach of contract lawsuits and all that kind of stuff, I don't handle that. So what I do is I draft, review, negotiate agreements between people that create music and people that want to use music. So my clients are artists, songwriters, composers, music publishers, record labels, managers, producers, and I do all the different agreements in between those types of people. So pub deals, record deals, library deals, placement deals, sync licenses, other licenses, copyright work, all those sorts of things. And so my clients range from independent, just starting out, where we're getting them all set up with their proper registrations and doing their first deals. And then I go all the way to Grammy and Emmy award winning clients, and also legacy writers and artists, estates and heirs, where I'm actually managing their catalogs for them and helping them make this music, keep working and keep making money. So
wow, that's like such a wide expanse of the information that you have to keep, the knowledge that you have to keep in your brain. It's a lot of things. Yeah. And how did you get into music law?
Yeah, I just always loved music, and I did not know that it was actually a real job until college. A professor of mine said, "Oh, you're going to work in music." And I said, "Well, you're crazy. I'm not a musician, so what am I going to do?" And then my college actually had a music industry program, and so I started taking the first classes, and I started learning about what agents do, what managers do, copyrights, contracts, and I learned that there's actually a real job of a lawyer that can handle the copyrights and the contracts and protect creators from getting screwed. And I was like a fish to water. I just got it. It made sense to me. It was really exciting. I thought it was like the coolest job ever. And I said, I'm going to do that. And then I went to law. Yeah, and I did it. I went to law school specifically for that purpose, and then started my own practice as soon as I was licensed.
Wow. Yeah. That's amazing. You really have set your eye on what it is that you wanted and went and accomplished it, and in such a big way, having your own practice, being so accomplished, and it's really inspiring, I think, for everybody on the call, for myself, to see, somebody like you really doing it.
Thank you.
Yeah.
I mean, well, everybody in the class, everybody's doing it, right? Everybody's working for their dreams and stuff. So that's great.
Yeah, but it takes that perseverance, and it takes hard work and following through and following up, and you're doing that. So
yeah,
we're lucky to have you, and I'm just going to dive in here then to some questions. And I'll just start at the top. So copyright arrangement. This question is, so I've arranged a popular pop rock song for violin and piano. It was discovered by a music soup. I gave clearance to use my master. The show then used my arrangement of the song and had their composer simply rewrite his own version based on my arrangement. How does an arranger in that situation secure publishing rights on their own arrangement, or can an arranger receive an rearranging fee?
So for arrangements, are derivative works. So whoever is the copyright owner of that composition, and which is most likely a music publisher, is going to want to own any arrangements of the song. So you probably will not get any copyright in a new arrangement unless you're arranging something that's in public domain. Potentially if you have like a lot of, clout or something, maybe you could get partial ownership of the arrangement, but usually you won't. It's possible, again, that a publisher could pay you for doing that arrangement. But I mean, to do any sort of adaptation, derivative arrangement, you need permission of the copyright owner. Again, usually the music publisher, unless the composition writer is self-published. So even sounds like this person potentially did this arrangement without even getting permission, and really had no rights on the composition side, had rights on the master side, but not on the composition side. And then it sounds like, I don't know what this supervisor's person did, if they got permission to then do an arrangement, if they just copied this arrangement. I don't know. It sounds like somewhere somebody didn't get the right permission.
Right. Yeah. But I think that is but you've answered the question well, and knowing where to look for, where you can actually cover yourself or not, and where you're going to get paid or not. So great. Thank you. Next question. I know I've posted this to the group. Okay. I'm wondering how you get paid for owning the master of a song, both for writing your own song and for re-recording a cover. Where do you register the master recording so that you can split percentages between everyone involved?
Okay. So master royalties, I'm glad that this question clearly separates composition from master, and I think you guys have probably gone over that in the class. Composition and master are considered separate entities. So for master, there's going to be sales royalties, there's going to be streaming royalties, there's going to be digital performance, which is like SiriusXM, Spotify, all those digital service providers. And yeah, those are, and then sync, master use. So if you have created a master, whether it be for an original song or a cover, if it's your master and you own it, you're not signed to a record label, then you would get paid on all of those types of uses. As far as registration, you would want to register it with Copyright Office. And then if you are co-owning that master with other collaborators that you're working with, then you'd want to have a written agreement stating that it's being co-owned between these particular people and what percentages, who's going to be managing, does everybody manage their own share, or is one person the one that handles everything and just pays the other people? So you would have an agreement, you'd register it with Copyright Office, and then you'd also want to register with Sound Exchange, because that's the entity that collects the digital performance royalties. So Spotify, Pandora, all that kind of stuff. And then the agreements, because people, this might be a follow-up question, because when I talk about this, then people are like, where do I get those agreements? So best way is to have an attorney draft it for you. If for some reason you can't do that, it's not, it's too expensive, you're afraid to hire an attorney, whatever, I would not go get free online templates, because they're usually wrong. I will, if you'll just putting out there as a resource, not trying to do like plug for myself, but I do have a website. In addition to my practice, I started a separate company called Indie Artist Resource, which has the most needed templates for independent artists and musicians. So those templates are on there. If for some reason you can't have an attorney draft it specifically for you, then that's another option. So
that's amazing. I'm just going to type this in the chat.
Yeah, it's just indieartistresource.com. And then if anybody wants my website, I mean, we'll probably do this at the end, but since we're on the topic, my website is themusicindustrylawyer.com. If anybody wants to know more about me. So
cool. Brian's saying he loves your site. That's
Thank you, Brian.
Thank you. I love that site. Yeah, that's incredible. So that I can't wait to direct people to that. Yeah. Mark says, follow up from the previous question, what is the best way to find the publisher of a song if you want to do a derivative?
So the way that we typically do it is we look up the song on either ASCAP, or we look in both of them because you don't know necessarily which one it's in. You either look in the ASCAP database or the BMI database because they have public repertoire. If you can't find it in either of those, you can try the CSAC database. But, you know, if you can't find it in any of those, then, I mean, you'll have to do detective work to, like, contact the person and find out, you know, who owns it, or have someone like me investigate who owns it. But usually you can find out from the ASCAP or BMI database because it'll list the writers and the publishers. You know, you can just do that, and then you contact the publisher, and, you know, they'll have a form that they want filled out, or they'll want to know, you know, how it's going to be used, what you want to do. They'll probably want to hear it, that sort of thing. Somebody's asking about Harry Fox. I don't know why. I saw that pop up.
Yeah, Harry Fox. But maybe they're saying, is that where you look for that information too?
Yeah, you can look on Harry Fox. I mean, that is another way. We usually just use ASCAP or BMI. It's the easiest way, but you could look, yes, as a source to check. Yeah, you could look on Harry Fox as well. Not everybody is signed up to look on there, but yeah, if you have a Harry Fox that you can log in and check it out, you can do it that way as well.
Those are such great, so much good insight. I think these kind of questions come up all the time, and having somebody who has such clear, precise answers and resources to go to is just, it's priceless. So thank you so much.
Yeah.
Let's see. It would be great to get sort of a checklist of what you need to look out for in various standard contracts, what you do need in your co-writing, production, licensing contracts to make sure that your contract will stand in court if needed, and if there's any red flags. And maybe kind of you've touched on this, like it might be kind of outlined in your website, but if there's anything else that you might kind of just go through, what red flags?
Yeah, I mean, that's a really broad question. So, I mean, we'd be here like all like into the late hours of the night if I'm like, let me explain every clause of these contracts and like what to look for. I don't have like a preset checklist of each contract. I mean, for a co-writer split, I mean, you need to know who the parties are. You need to know what the splits are. You need to know who's administering and how administration is going to be done. And if somebody's administering for other people, then there needs to be, you know, other terms in place as to how that's going to work, and like how the money's going to be split, and how the accountings are going to be paid, and then like a lot of boilerplate legal language, that sort of thing. For like sync licenses, I mean, that's going more into like how the song's gonna, like who owns the song, how the song's gonna be used, where it can be used, so like territory, media, like what the fee is, like if there's any reuses, if there's any options, if there's any performance tied to it, you know. So I mean, that basically gets to the parameters of like who, what, where, when, why, and how much, library agreements. I see a lot of like agreements for libraries or placement houses, which a lot of people come to me and say, oh, I got offered a co-publishing deal. And then I look at it and I'm going, this is not a co-publishing deal. This is a library that wants to take your copyrights, or this is a placement house that wants to take your copyrights for a very small amount of money. So those are agreements that you have to be very careful about, because in a lot of cases you're giving up a lot for not very much. Like if it's just like throwaway songs, like what I always tell my clients is if it's like throwaway songs that you don't care about really, and you're like, oh, I'll just write another one tomorrow, or like I wrote that 10 years ago, it's not doing anything, like if it makes the money, great, then maybe it's not as concerning. But otherwise, if these are like songs that are important to you that you feel you could do things with, and you're like assigning your copyright away for no money or a very small amount of money to a library that, or a placement house that you don't even know if they're going to get placements for you, that's maybe like something I would think twice about, because I've done a lot of deals with like placement houses for people, and and then when I talk to my client like at a later date and I say like, well, how's it going with that company? And they're like, yeah, I never even heard from them after we signed the deal. Like they've never got me a placement. So you really have to kind of like vet these places out, and exclusive versus non-exclusive makes a difference, because a lot of supervisors don't even want to deal with non-exclusive represented tracks. You probably talked about all this kind of stuff in the class, Sonnet, that like they don't really like non-exclusives, they like one stops, like all that kind of stuff. So we have but I mean at that point, like a lot of these deals, like they're asking for like half to full copyright. The percentage split is like, again, people tell me like I got a co-publishing deal, but like the percentage of money that they're splitting is not split the way a traditional co-publishing deal would be split. So it's kind of this like weird hybrid deal, and it's just a function of these companies realizing that it was valuable for them to own copyright. So
that's kind of scary. You want to make sure that you have somebody like you around to make sure that you're not signing something that's in disguise like that.
Yeah, exactly.
There's questions coming in, but let me just continue.
Yeah. I'm glad you can look up, because I just see them like popping up and then they go away, and I'm like, I don't know.
I'll make sure I'll man them. Okay, so would love to understand the difference between publishing share and registering your publishing with your PRO. Are they the same?
Okay, no. So that's a great question, because people get confused a lot as to the PRO and the publisher. And a lot of people tell me that ASCAP or BMI is their publisher, and they're not. So ASCAP and BMI, all they do is collect and pay out royalties for public performances. So when your composition is performed on radio, television, streaming, bars and restaurants, live events, that sort of thing, they track and collect those and pay them out on your behalf. So the way they pay those out is there's a writer's share of income and a publisher share of income. Basically, it's like if $1 of performance money comes in, like half will go to the writer and half will go to the publisher. The PRO will always pay the writer directly, and then the publisher's share will go to the publisher, and then depending on what kind of publishing deal you have, the publisher will either keep that full amount or they'll split it with you based on your contract. And if you are your own publisher, then sometimes they'll just pay it both to the writer, but what's a better and cleaner practice is to have your own publishing company set up with your PRO. So if you're whether you're signed to ASCAP or BMI, you have to set it up with the same one you're signed to as a writer. But you basically pick a name to be your publishing company. It's like a doing business as, and you just fill out a separate application with them, and then they will pay, if you're self-published, they will pay your publisher share to this publishing company. And you can't really see my air quotes right now. But what a publisher does is a lot more than just dealing with performance royalties. They deal with all the different royalty streams, licensing requests, putting writers with co-writers, and pitching, like lots of stuff. So in that case, the money's going to be split based on the contract. I mean, yes, there's still kind of that writer share and publisher share, but it's going to be split depending on how your contract is and what the percentage split is within your contract. So hopefully
that makes sense. We've got a couple follow-up. So what about having your own publishing company versus an administration deal?
So when you have an admin deal, so if you have your own publishing company, you're doing everything yourself, unless you're like hiring some royalty service or something to do something for you. If you have an admin deal, you have another publishing company doing all those functions of a publisher for you. So you still have your own publishing company, but everything's going to get paid to your administrator. Your administrator is going to take their fee, and then you're going to, again, it's like I was saying, it's based on whatever contract you have. So the administrator will take their fee, and then you'll get whatever it is based on your contract.
Right. Great. Yeah. Okay. I think that really helps clarify things for people, because it's like publishing used in two different ways in a way.
Yeah. Well, I mean, PROs, like performance, this is one aspect of publishing income. So there are like different income streams for publishing. So there's mechanical, there's print, there's sync, there's performance. So there's these different, different royalty streams. So ASCAP and BMI, or your performance rights organization, they just function to like help collect these performance royalties for you. Because if you had to like have a license with every bar and restaurant in the United States, or every television station, or every production company, right? I mean, you would never be able to keep up with all of this stuff. So these are like big companies that have the means to handle it on your behalf, but they're collecting agents. They're not your publisher. They're not pitching your music. They're not handling your other types of income. So,
right. That's great delineation. So this month we had an assignment with the class to do covers. So there's a couple of questions that have come up around covers. One being, I guess this came up a couple of times, and how much you can change it with it still being, well, I'll just read the question. So does changing the arrangement for a song and or changing how you sing a certain word, as in singing it at a higher note than the original, mean you're doing a derivative work? I'm just curious how much wiggle room there is typically when you're modifying lyrics, things like changing he or she, past, present tense.
Yeah, so what they refer to as incidental changes are okay. Like he to she, that's like an incidental change. Maybe you go up on a note or something while you're singing it, like that. It just, if you can tell that it's like similar to the original version. I mean, I don't have like the legal language in front of me of what it's like defined as, but basically it has to be like close to the original version to be a cover. So again, like he, she, that kind of thing, like you put a little bit of, your own flavor while you're singing or something, that's okay. If you're changing lyrics, beyond like he, she, or, I, or, something like that, then you start going into derivative territory. If you're adding new music and like writing new parts that you're adding in and or like rearranging stuff, like you're going into derivative territory. So, if you're not staying like true to the original, then it's derivative territory. I mean, you can still do it in a different style, but you know, again, it has to be like close enough to the original. So sometimes it's like people argue it as like a matter of interpretation as well, you know, but that, I mean, that's the guideline that I go by is, you know, so.
That makes sense. Yeah, we had like about 4 questions around that, so that's super helpful. Okay, remixes. On the major label, it's pretty straightforward because the label owns both masters and songwriting publishing remain the same. I don't know if that's okay.
Well, correct. I mean, before you go on, if I can jump for a second, like the major label is, so publishing, again, going back to that concept of the composition and the master are 2 separate entities. So usually the music publisher is going to own the composition and the major label is going to own the master recording, unless that person is signed to a 360 deal and that label is also handling the publishing. But you wouldn't necessarily know that. So, I mean, unless you know that that's a particular situation for that type of, or for that particular composition, then you want to always think that it's not necessarily the same company that owns both the master and the composition. So
that's good to make note of. It's not always going to be that. Yeah. So in terms of indie songs with remixes, how are the rights to the master and the music licensing splits represented? They gave a couple of scenarios, but I think that just in general, how would the master and licensing splits work for the original producer and the remix producer?
Okay, so producers are always by contract. So whoever the master owner is going to be the one that gets paid. So if we're talking about an indie situation where somebody owns their own master, then they are the master owner that's going to get paid. And how the producer or the remix producer get paid are going to be based on the contracts that person has or that master owner has with the producer, the remix producer, all these people. So that's just going to depend on the contracts.
Okay. So, Jessie, I sort of simplified your question. If there's something more there that you wanted to ask, you can, but I think that helps.
Yeah, I'm just a little confused if the music is completely changed, right? Because that's what usually what a remix does. The original producer who is part of the master needs to renegotiate with the other parties. Is that what needs to happen, or they just decide to do a work for hire?
So the remix producer is changing the music?
Yes.
Okay, so I mean, but the master owner, I mean, does the producer own any portion of the master, the original producer?
Yes.
Okay, so in that case, then the producer and I'm assuming the artist are co-owning the master. Yeah, okay. So those parties would have to come to another contractual arrangement with the remix person as to who owns what and how the payments are going to be split. Because, you know, it can either be like this remix producer gets, you know, ongoing payment, like a royalty kind of payment. But a lot of times these remix guys are like, you know, it's like a work for hire and they don't own anything. And sometimes they just get paid like a flat fee. So again, depends on who you're working with and what the situation is that you've worked out.
Okay, because I'm a producer, a singer, and a songwriter, so I wear all 3 hats, and I just want to make sure when I'm working with other people in 1 or 2 of the capacities that I'm wearing.
Right. Well, I mean, as a producer, if you're producing somebody else, you know, again, if you're part master owner, then you need to be in on what happens for any uses of the master, but also potentially you know, you have an attorney that's negotiating for you that, you know, your, like any royalties or anything like that are not getting reduced by future, you know, remixers or other people that come in. So.
Yeah, that's exactly what I wanted to secure.
Yeah. So that would be, again, a negotiation thing, a contract thing. So.
Awesome. Thank you.
Yeah.
So Oz has the question here in the chat, which he says, what does it mean to own the master? I always thought it was the person who owned the stems of the song and create parts if necessary. Is that correct?
No. So, I mean, any like engineers, producers, like they come in and they, make stems. Like anybody can be your Pro Tools person. But again, like typically it's the artist or the label that's owning the master. In an indie situation, if there's no label, then it's, the artist is going to probably be owning it and hiring these producers and engineers. It can be a gray area. So like for my clients, I always have agreements in place to show that that it is, the artist or my client or whoever's the one that's hiring these people is owning the master. So, again, it should be like the person whose work it is, but sometimes people argue that, they own a portion of it. There's a difference where some of the confusion might be is that there's a difference between owning the physical item and owning the copyright to it. So like, yes, you can like maybe physically own like a hard drive with files on it. Like that's just a physical product, but that is separate from the intellectual property. It's the same principle as if like if you go to, I mean, again, like nobody's buying CDs now really, but if you go buy a CD, you own that physical CD, but you don't own the copyrights into the music. So that maybe that's where the confusion is about the stems and that sort of thing.
Yeah. Okay. That makes sense. Awesome. Great.
Yeah.
So, hi, Erin. My question is to do with cover songs. If you arrange and re-record my own version of a classic and have done it in a completely different style, and I can't find any other versions like that, is there something I can do to safeguard this version from simply being copied by a music supervisor or producer?
Not really. So again, like we talked about before, I mean, you can copyright your master of it, but as far as the composition side, like somebody doing it in the same style as you, again, you don't own a copyright to that arrangement necessarily, especially if it's like enough to be considered a derivative work. So that would be what, the publisher would own that. And, if they don't know about you and then they find out about you, then they'll come and tell you that they own that. So,
right. Yeah.
So yeah, unfortunately there's not really, I wouldn't say there's a way to change that, but again, you can copyright your master. So at least if somebody's using your version, then, you at least get paid for that part. Again, I mean, you could always contact a publisher and see if you can get like something for it, but like depending on who it is, a lot of time they'll be like, nope, we own that. Thanks. Like, thanks for bringing it to our attention. So.
Right. Can you talk about errors and omission insurance and if artists need it?
Yeah, I mean, people keep like lately, I don't know, that question's popping up a lot. Most people don't have it. So I'm not sure why that keeps popping up all the time. I like the only purpose would be maybe if there's like an infringement, like if somebody's accusing you of infringement, but most people don't have it. So I don't see like a huge, I mean, if you really feel like you need it, you can go get quotes, but most people don't.
Yeah. I think it comes up with like licensing agencies. They sometimes have them because they're the middleman between the agency or the network, and the network requires that. But for individual artists, I don't know if it's required of you necessarily. Right. Yeah.
Yeah. No, agreed. I mean, I guess a company could ask for it because that way, because because when you're signing a deal, like you have to indemnify the company, saying that like, oh, if you get sued for infringement because of like something that I did, then like I'm responsible for all your costs. I mean, so potentially they might want that if they, you know, feel they need it, because otherwise you're not going to be able to pay their legal costs or something. But like I said, most people really don't have it.
Yeah, exactly. And it's a big deal to get it.
Yeah.
Yeah. Okay, so what else? Are there situations in which retitling might be legit and useful? So like when licensing agents might want to retitle.
Yeah. So the reason why they retitle is because they're taking income on the back end. So basically they're saying that like any performances of that placement that they've gotten you, they will share in the performance income from that. That will be out of the publisher's share that we talked about earlier. So it's legit in that sense, but the problem with it is that then you have the same song with multiple titles, and if a PRO is using like the digital technology that like listens to the songs to see what song it is, then they have like their watermarking technology or their like listening technology doesn't know which song it is because it's the same song but with a different title. So in that case, like they get confused and they don't know who to pay. So then they don't pay anyone, and then they still end up going back to the cue sheet. So for that, like I'm not a big fan of it as far from the writer side or the creator side. I'm not a fan of the retitling. I understand it from the company side, because how else are they going to track the back end from performances from placements that they've secured? But it kind of makes for a little bit more of a mess, and they're going back to the cue sheets to resolve disputes anyway. So just make sure that the cue sheets are in and correct.
I think we have time for a few more questions, and there's a lot here. So if you are not a U.S. citizen, can you trust the PROs in your own country, or are there things that you need to register in the U.S.?
So it depends on your country. So there's been like a couple, I think Spain has been having like some difficult PRO issues lately. But theoretically what happens is that you're registered with your society in your home country, and then they have an agreement with ASCAP or BMI or both. And so ASCAP or BMI will then pay your home society, and your home society will pay you. Again, you just kind of have to pay attention to what's going on, and it depends on the country and how well they do things. But you know, most of them, like, you know, PRS in the UK and SOSM in France, and you know, those kind of like they do a good job. So I mean, again, it just kind of depends on the situation. But if you're registered with the home society, you're probably not going to register directly with ASCAP or BMI.
Okay, that's great. That makes a lot of sense. What documents do you need from music supervisors to show a song is cleared, that it's one stop? Is it something like a split sheet sufficient?
Like the supervisors asking
they're like, oh, is this one stop? I mean, they don't normally, they just normally take your word for it. But
yeah, I think they normally take your word for it. I mean, if you really needed it to be one stop, I mean, somebody was just asking me about this, like somebody was demanding the copyright registration certificate. So, I mean, you know, I mean, and that usually doesn't happen. And they were like, why do you need that? So it, you know, yeah, I mean, if you have a like contractual documentation or you have copyright registrations, you can always provide those if they need it, but normally they take your word for it. And I mean, sometimes it doesn't always like go well. I mean, one time a client of mine where we represent the composition, like the master owner cleared both sides and they paid us, but like the point was is that they weren't supposed to clear on our behalf. And so despite the fact that we were fine with the usage, I had to go back to the supervisor and say, you need to provide us with our own license. And they were like very afraid that we were going to like pull the usage right before this film came out, which we didn't. We just, we were willing to make it work, but stuff like that happens. And they're like, well, he told us that he had the right to clear like on your behalf. And I'm like, well, he told you wrong. So you're going to have to deal with that, because he warranted and represented in his contract that he had the rights to clear. So you're going to have to deal with him on that. But I'm just telling you, we need our own license. So, and it worked out. So
I'm sure you have so many stories. That's so like the things that kind of come up in this world are some things can just never happen again, but you probably see so many things.
Yeah. It's interesting sometimes.
Yeah. I'm sure it's interesting. It's exciting.
Yeah.
How it varies, Yeah. So I want to wrap this up. We've had so many amazing answers and questions, and you've been so helpful. And I know that everybody's going to head over to your website and check you out and check out your resources there. And just thank you so much for taking the time to share this information that is so valuable and takes years of studying and practicing to know all these answers. And we're so, lucky to have you here with us.
Yeah, no, my pleasure. Thanks for having me. Thank you to everyone. I'm seeing all these little comments popping up saying thank you. So thank you. You're welcome, guys. I'm happy to do it. Happy to, come back if you, have more opportunities that you need me to weigh in on some stuff. And
we definitely do. So we'd love to have you back.
Okay, yeah, happy to. And if anybody needs anything, feel free to reach out. So
what's your best email?
So there's probably the easiest way is just to go to my website at themusicindustry.lawyer.com, and there's a contact tab, and there's a form there to fill out. My email address is really long, so that's like the easiest way to do it. And then you can just put in the questions that like you're from Sonnet's class, and and then if you need a contract or a consultation or whatever, we can set that up. So that's
great. That's an amazing resource, and you're just down the street if you're in LA, so that's really cool. Okay, so we've got your website, we've got your info, and we can't wait to have you back, and thank you so much.
Yeah, my pleasure. Thank you.
Have a great rest of the week, guys.
Bye, everyone.
Bye.